Yeah. Oh, let's shift to the Sentencing Reform Bill now, and let's hear what Goldie has to sit there and say for the first one. Thank you, Willie Jackson, for giving him that title.
Honourable Paul Goldsmith.
Mr Speaker, I present a legislative statement on the Sentencing Reform Amendment Bill.
That legislative statement is published under the authority of the House and can be found on the Parliament website. Honourable Paul Goldsmith.
Madam Speaker, I move that the Sentencing Reform Amendment Bill be now read a first time. And I nominate the Justice Committee to consider the bill. At the appropriate time, I intend to move that the bill be reported to the House by the 13th of February 2025. In recent years, we have seen a reduction in the use of imprisonment despite the increasing seriousness of offending coming before the courts. For example, the imprisonment rate for burglary offences with a maximum penalty of 10 years reduced from 30% in 2016 to 39% in 2022. The imprisonment rate for robbery with a 14-year penalty dropped from 74% to 58%. Public confidence in the ability of our sentencing system to deter and denounce offending has diminished, and this can't continue, Mr Speaker. The Sentencing Reform Amendment Bill has three objectives: to ensure real consequences for crime first, secondly, to restore the principle of personal responsibility for offending, and thirdly, better recognising the needs of victims, particularly those who have suffered through years of increased retail crime. Mr Speaker, the main features of the bill include, must make it clear from the outset that there will be real consequences for crime. I've become increasingly aware that the public frustration that all too often penalties do not reflect the seriousness of offending and the harm it inflicts on victims and on our communities. It's an established feature of sentencing regimes that offenders can receive discounts on their sentences for personal mitigating factors, such as previous good character. And while this in itself is not an issue, I'm concerned that over time offenders have grown to expect very sizable discounts. In some cases, these can be up to 70%, which can mean the difference between a lengthy sentence of imprisonment and a sentence of home detention. The Sentencing Reform Amendment Bill will put an end to this practice by capping the sentence discount at 40%. On current estimates, around 20% of cases involve discounts that exceed this cap. So I expect this policy will have a significant and measurable impact on sentencing outcome. I recognise there will be exceptional circumstances in which a larger discount may be justified, for example, when an offender provides substantial assistance to the authorities. For this reason, the bill provides a limited judicial discretion to guard against the risk of manifestly unjust sentences. The bill also clamps down on discounts for remorse and youth. All too often, offenders have been coming before the courts, each time claiming to have learnt their lesson. This rings hollow, Mr Speaker, for their victims who don't find it as easy to move on past the trauma and the loss that they have experienced. It's particularly frustrating to many when discounts for youth extend well into the mid-20s. We're not talking about under 18-year-olds, are treated differently in the youth court. The law changes I'm seeking to relate to New Zealanders who are over 18, for whom repeat youth discounts are harder to justify. The bill's focus on holding offenders to account also extends to unduly generous discounts for guilty pleas, especially those entered late in the day. When offenders drag out the court processes unnecessarily, they waste valuable court resources and add to the stress and anxiety that victims already experience. That's why I'm proposing a sliding scale for early guilty pleas that caps maximum discounts at 25% while diminishing benefits for offenders who enter guilty pleas later in the process, despite having an early opportunity to do so. It's an approach that's been adopted successfully elsewhere. I'm therefore confident it will be effective in ensuring appropriate discounts are applied without coercing guilty pleas. These sentencing reforms represent a decisive response to crime trends that are of particular concern, notably the alarming growth of retail crime. Everyone deserves to feel safe in their homes, but we've seen an increased victimisation in retail locations, which have more than doubled since 2018. We're all aware of the scourge of ram raids and other robberies that have hit small businesses hard, and the senseless acts of violence against bus drivers and other vulnerable workers. For this reason, the bill introduces several aggravating factors that are intended to result in tougher sentences for offenders who target, first, victims working alone; second, people who work in a business connected to their homes, such as dairy owners who live upstairs; and thirdly, public transport workers. The sentencing package reform also rationalises aggravating factors included in other legislation currently before the House, particularly in two scenarios. The first involves adults who take advantage of children and young people by encouraging them to participate in their offending. This highly irresponsible and selfish behaviour needs to be condemned in the strongest terms, not the least because it helps create a new generation of offenders. Second, I'm concerned about the phenomenon of people live streaming or posting their offending online as a means of glorifying criminal conduct and encouraging copycats. Both of these aggravating factors have been carried over from the ram raid offending and related measures bill, currently at Select Committee. These victim-oriented reforms are also supported by the revision to the principles of the sentencing, which gives greater weight to the needs of victims, Mr Speaker. Another element of the bill responds to the growing use of concurrent sentencing for offenders who commit further crimes while on bail, in custody and on parole. Victims are right to be concerned if the punishment for crimes committed in these contexts is simply rolled into the sentencing for the original offending. This has been a particular issue for correction officers who work in very challenging conditions, assaulted by prisoners, and find that the penalties don't reflect the crime. That's why we're changing the law to set a clear expectation that cumulative sentences will generally be imposed for offending on bail, in custody and parole, unless there is good reason. The bill also makes minor changes to the Sentencing Act to improve the efficiency and workability of the legislation, for example, making a protection order an option in sentencing where a person has been discharged without conviction for a family violence offence. We know that the proposed reforms to the Sentencing Act will result in more offenders going to prison, and we make no apology for that, Mr Speaker. Modelling suggests the prison population will increase by about 1,500 extra prisoners over the next 10 years. We plan for this. Much of the costs have already been factored into prison population forecasts. Mr Speaker, the Sentencing Reform Amendment Bill has a 3-month commencement period before the reform comes into force to allow time for everybody to prepare to make the changes. This bill builds on this government's ongoing work to restore law and order, including new laws to address gang harm, which was passed just this week, and reinstating the 3 strikes regime. Mr. Speaker, the Sentencing Amendment Bill strikes the right balance between ensuring real consequences for crime and maintaining judicial discretion to avoid unjust outcomes. I commend this bill to the House.
He talks too much.
So I wonder, does that make... So one of the factors of our laws is you've got, at the point of trial, the laws have to be based... so to be tried on has to be based on the law of what it was at the time of the offence. With the March 15th Christchurch killer, people were signing petitions to reinstate the death penalty, even that they wouldn't have been able to actually have him charged and sentenced to death because the death penalty wasn't a case when he live streamed his crime. And his lawyers would be successful if they tried to retroactively add the law. I would mention about the Texas BTK, where they did not give the death penalty to BTK because he committed the crimes at the point when the death penalty was not law, before it got reenacted by citizens' referendum. But when it comes to sentencing, does that mean it applies to at the point of when the crime's committed, or at the point when you get sentenced? Because that would be quite interesting. At which point does that get done? Especially if the courts are slowing you down, or if the prosecution slows you down, should you be punished for someone else slowing you down in the system? Or is that where it's exceptional circumstances meant to kick in? That's my 2 cents worth. Everyone else want to put in your 2 cents worth?
I want to know how restorative justice fits into this equation.
I don't think it does.
No. I don't have much commentary on this one because admittedly I was too busy studying to become a chemical engineer. but yeah, I mean, I would like to see more spoken about when it comes to restorative justice, because I think preventing crime is more productive for society than throwing everyone into prison. He seems really excited about that fact. That's a bit concerning.
There's a balance that needs to be had, right? Because of course you need to prevent the crime in the first place, but what about when the crime is committed? And you need to throw someone in prison when that crime is committed. I just think the issue with this bill is that, from what I looked up, there was literally no experts at all who were supporting this. I couldn't find a single expert from the left or the right who supported this bill whatsoever. It has no support other than the coalition agreement between, I think it was New Zealand First and National. I can't quite remember, but it was between them.
That's becoming a common trend.
Yeah. A lot of these controversial bills are just the coalition agreements.
Yeah.
And their entire argument is that it's a coalition agreement.
Yeah, I mean, like the one about the public transport, yeah, it sounds all great, but the person who is about to whack someone, if they whack a bus passenger on the bus instead of the bus driver, does that mean the sentence is different? You know, is it difference between whether you whack a train manager, or for us oldies out there, a train guard, versus, say, a member of public on the train? Like, you know, what is going to be the difference in there on that particular aspect? Does a off-duty Transdev employee taking a ride home have different protection versus the on-duty Transdev employee who's sitting down there opening and shutting the doors on the train?
Good question.
Yeah, I think with this one, not an awful lot to say on this one, but I think potentially some of the reorientation into focusing on the victims of crime, that could be potentially quite positive for in terms of allowing victims of crime to have a greater voice through the justice system, because I certainly know at the moment there isn't a great enough ability for victims to have a voice and participation through the justice system. It's certainly a very cold process, and victims don't have much of an ability to have their voice heard through that process. But it was pretty clear from Goldsmith's comments that this is about putting more people into jail. And I think ultimately, if your answer to in terms of justice policy is to put more people into jail, I think you need to re-look at the way that you're thinking about justice policy, because it's never going to solve justice. It's never going to solve criminal offending if you're just going to lock up more people, because ultimately building prisons is, and I'm going to quote Bill English here, and I thought that I would never do that, because ultimately that's never the start to a good outcome. But Bill English, I mean, he said it. Prisons are a moral and fiscal failure, and if you're building prisons, that's never a good place to be in. And
actually, building a prison can actually cause a lot of problems when it comes to representation reviews for some councils. It is part of the reason why Upper Hutt City Council gave up on having Māori wards with the referendum, because they already had an issue with the representation review for proportional representation, because the fact that the military base and the prison were across the road from each other. And in the case, so whoever represented that ward effectively would have had a lower bar to get over the line versus other areas of the city.
Interesting.
So that was something, for the people who had an Upper Hutt City Council, they had an issue in there because 4% of the population are prisoners. And 4% of the population sits there and plays with a representational count when it comes to voting. The same would also apply for, I think it's Te Awamutu or Otahonga District Council, where a good portion of the population are prisoners. Same with West Spring Hill Correctional Facility, And also, once they've been in jail if they're sentenced to 3 years or longer, they get struck off the electoral roll, but the population has to still be counted in proportional representation. But hey, that could also change. They might make it that you get sentenced to prison for 1 day, you get struck off the electoral roll, which the Electoral Commission absolutely hated when that was in place in law from 2010 to 2019.
I've always believed that the purpose of prison should be a place where people can rehabilitate, but also to keep members of the public safe. Not necessarily a place of punishment, but a place of where justice and where other things like research can be conducted on how to rehabilitate people. It kind of disturbs me how we go back to this idea of we need to send them to this place for long-term punishment and then we'll release them back out again. It's like,
but I mean, some people sit there and believe in collective punishment. Look at how many people sit there and go, oh, one cyclist was a bad driver, so I'm going to punishment pass every single one of them. I hope I don't knock them off in the process. Oh, and if I knock them off, that's I should be immune from prosecution because I'm a king.
Yep.
I've always wondered, though, is it possible that people cannot be rehabilitated? And if that is the case, what do you do then?
Yes, but you've actually got to prove the point, is that person beyond rehabilitation?
Once you reach that point as
well. Yeah, I do believe that. I mean, that's what the sentence called preventative detention was for. That is a sentence for like the Beast of Blenheim, which is actually the reason why that sentence came into place for sexual offending was because of the Beast of Blenheim, and he was proven as an example of why that sentence needed to be in at the point he committed his crimes.
Yeah, I mean, some people need to stay in prison. I'm not going to deny that, but it's about.
So that's why you have parole boards. That's why you have, that's why you have systems in place in there. That's why you have parole. I know 2 parole board. Actually, no, I know 3 people who do parole board prison stuff, and it's a very important function of the system. Is going through there, and that's where you work out these things during parole. Are they being a model prisoner or are they being a delinquent? That sort of thing there. And that's the whole point of, the parole part. Because while you've got someone on parole, you can continue monitoring them for the rest of their sentence. If they serve the maximum of their sentence, they're straight out the door. They can commit crimes, and there's nothing you can do, such as breach of parole. That's the worst outcome. Parole means you can keep the checks and balances on there. People who get paroled are less likely to reoffend than those who sit there and serve near the maximum of their prison sentence.
I'd love to see more parole officers.
These are parole board
services. It's not going to happen.
These ones are parole board members that decide who gets released.